You're listening to the Legal Paige podcast, episode number 8. This is part 2 of our discussion from last week on the essential contract clauses for any service-based company. So last week, you guys, we talked about the entire agreement clause, the description of services clause, the venue and jurisdiction clause, the severability clause, the transfer clause, and the billing structure clause. Today, we're adding on to that with a few more essential clauses. So are you ready? Let's do this, Legal Pagers. You're listening to the Legal Paige podcast, where we chat about life and business with a legal twist. I'm Paige, attorney and photographer helping online businesses and creatives tackle their business dreams without breaking out in hives. No more legal mumbo jumbo. This podcast features simple, bite-sized advice that'll have you legally legit in no time. Are you ready? Let's get started. Okay, friends, again, as a reminder before we get into this episode, I am legally obligated to give my legal disclaimer. So I'm an attorney, but I am not your attorney. And what that means is that all the legal information that I give on the Legal Paige podcast is intended for the masses and a large variety of businesses. You are not my client, and I am not your attorney until you hire me and we sign an engagement letter for me to work with you specifically on your legal issues. Okay, so let's get started. This is part 2 of our Essential Clauses series. And as I talked about in the intro, remember that last week we discussed some really important clauses, but today we're going to add on to that list. And what that means is that what we're talking about today coincides with last week. So remember, these are all the clauses that you need. So please make sure you do that. Today, we're going over the intellectual property clause, the counterparts and facsimile signature clause, a communication clause, an indemnity clause, an arbitration clause, canceling and rescheduling clauses. They can be 1 clause or 2 clause. We'll get into that, and a force majeure clause. So let's just start right out and get into this. The next thing on the list is the intellectual property clause. This is a really important clause for photographers, videographers, designers, anybody who has any type of copyright, intellectual property in whatever they produce. So remember that a copyright in general is a legal right which exists in the United States that grants the creator of a type of an original work the exclusive rights to determine whether and under what conditions that work would be able to be used by others. And people talk about this all the time in the photography world because you have a copyright the minute you create something. So photographers, when you snap a photo, you own that copyright the minute you compose the shot and click the shutter. Videographers, same thing. The minute that you press record and you're recording it onto your memory disk, you own the copyright to that. And designers, same thing. The minute you start designing something, whether that's a graphic design, whether that is a calligraphy design, invitation suite, anything like that, you would own the copyrights to that. So in this clause, you need to clarify the rights to your intellectual property, and you need to explain that the intellectual property is owned by you. You can also ensure that it's owned by your company. So I suggest in your copyright intellectual property clause, you would have something like copyrights are owned by, say, Paige Griffith doing business as Paige Marie Photography, if I was going to do that for my photography business. You can also transfer and give your rights to your clients as well. So this is important if you're like an independent contractor and you're working for another company. So say you're a copywriter working for another company, you actually own the copyrights to your words the minute that you're writing them, but you would want to ensure in your contract that you are transferring the ownership of your copywriting and all of the words you create for another company to the company. So the company owns their own intellectual property and you have no rights over it. This is very, very important for entrepreneurs in the online world to lay out who owns what, copyright-wise, trademark-wise, all intellectual property rights in the initial contract. Because honestly, the biggest issue I see are copyright disputes when your client or somebody that you're working for or a bride or a vendor uses your photos or your designs for their own benefit without you getting paid a dime. When you own copyrights, you have the right to be paid for anything that any third party uses with your copyrighted material. Next is the counterparts and facsimile signature clause. So a counterpart clause would state something that makes it clear that the agreement may be executed in any number of counterparts. And what that means is that each part is a duplicate of the original. So this is really important when you're signing things online, and it also coincides with the facsimile signature clause, which I'll talk about in a second. But counterpart clauses are useful when all parties want that assurance that each copy of the agreement is treated as the original. So back in the olden days, obviously with contracts in no online world, you would have to physically sign the document and it would have to be the original with the other party for it to be valid. But now we execute contracts all the time in the online world in various stages. So you send a contract, say, through your client management system, like Honeybook or Dubsado or 17 Hats, and you send that to your client. And then they sign it, and then you are notified that they sign it, and then you sign it. So it's signed in different counterparts. With this clause, it ensures that everything is the original once both parties sign it. A facsimile signature clause, which is included in this, I just have this as a dual clause altogether. And the facsimile signature means that an electronic signature of one or both parties is still valid and makes the contract still the original version, even if it's not hand signed like we did in the olden days. So obviously super, super, super vital for any online entrepreneur who is sending contracts back and forth to have. Next is a communication clause. I am going to give a shout out here to my friend Kinsey Roberts with the She Creates Business podcast. We met last year at the Creative at Heart conference, and she told me all about this clause. And I was like, oh my gosh, Kinsey, you are a genius. I thought it was so smart to have in your service contracts nowadays. Since we tend to work remotely and we are bad at setting expectations of our work hours, a communication clause states your office hours, your typical response times for emails, and it informs your clients that you answer primarily through email and not through text. So even if they have your cell phone number, you will only respond via email. And so you put that in your communication clause. A communication clause is also a good place for photographers and videographers to add into their contract when they will give their phone number out to clients prior to a session or a wedding. So if you're a wedding industry professional, this goes for really anyone, like a wedding planner, anything like that. You want to say that your primary source of communication is through your email and that you will respond, say, within 48 hours to 72 hours after somebody has contacted you via email. That's your typical response time. You want to say in this communication clause that your office hours are Tuesday, Wednesday, Thursday from 9 a.m. to 4 p.m. You could do Monday through Friday, 8 a.m. to 5 p.m., whatever it is, and that what you're going to respond to when. This is also very important because you can put in there, I will not give out my personal cell phone number until, say, a week prior to the wedding for my client to contact me with any essential things that come up in a time that come up, more timely than an email maybe. An email communication is a little bit slower. So if it's a bride or a groom and they have a wedding coming up on Saturday, I would suggest that in this communication clause, you will give your phone number out to clients 3 days before the wedding, 7 days before the wedding, what have you, just in case the client needs to contact you for anything urgent. I love communication clauses. I'm adding them into all of my contract templates now. I think they are a beautiful thing. Just think about that power that you can have when you have a communication clause as an entrepreneur in the online world, where You're sitting back, you're having margaritas with your girlfriends on a Friday night, and you get that ominous text from a client. And previously, for the past year, you probably would have responded back because you want to be that really awesome business owner. But you can feel good knowing that you can set that phone aside and not have to text that client back because you have made it clear from the beginning of your relationship that you do not answer communications after your office hours and that you will respond to them when you're back in the office. That's why I love a communication clause. Whew, we are going over a lot, but it is all so important. Maybe you're freaking out right now because you're missing some of these clauses. Don't worry. A lot of service-based businesses are, but I've got your back and I'm here to make sure that you don't end up in one of those sticky situations. So to find out what's missing in your contract, I've got an easy legal button for all of your needs. Just go to the link contractquiz.pagemarie.com and answer a few super fun quick questions. It will walk you through different scenarios to determine exactly how your specific contract stands right now. So if you're sitting here like, help me, Paige, just go answer those questions and we will get you legally legit in no time. Let's hit that easy legal button, friends, at contractquiz.pagemarie.com. The next is one of the biggest things that needs to be in your contract is an indemnity clause. Basically, you guys, an indemnity clause is just some type of contractual transfer of risk between the two parties that are contracting together. And it usually prevents loss or compensates one of the parties for any loss which may occur as a result of you participating in a certain event. This is important for like brides and grooms to indemnify you for anything that were to happen at a wedding that's outside of your control. As a wedding industry vendor, you don't want to be hailed into any type of legal dispute just because you were a vendor there and maybe you weren't party to what happened. It also just really explains who's liable for who, when are they liable, and it just commits that compensation of transferring any harm or liability or loss arising out of the contract altogether. I also think an indemnity clause is really, really important if you're providing services as an independent contractor to others. So all of you copywriters, editors, virtual assistants out there listening, really anyone you guys out there, a coach, something like that, you want to have an indemnity clause in your contract because it's a promise that you make to be hired and then you accept the risk of loss or damage that you may suffer as a result of your work just because you're an independent contractor. This is really important and vital as an independent contractor to have, because it lets people know that hire you that while you provide a service for them, that they don't have to provide insurance for you and that they are not responsible for anything that happens while you're doing business and working for them. As an independent contractor, you want to be completely independent. If it looks anything like an employee relationship, that person who hires you would be liable for anything you do. So I think that's really important to explain that and extrapolate upon that in an indemnity clause when you're an independent contractor. So next thing, make sure you have an arbitration clause in your contract. I truly believe in arbitration as the best way to settle any type of dispute before a lawsuit happens. So you set forth the procedure for settling any type of disgruntlement or miscommunication or dispute that arises from the contract with the other person on the other side. I usually always tell people to include the arbitration clause in their contract because it requires all parties to arbitrate, which is a type of mediation, but arbitration's a little bit different. And arbitration is ran by the American Arbitration Association, and it is a way to have a third party mediate. They are called arbitrators. So they arbitrate the dispute for you. And then that saves you from bleeding money and going into court, and it saves you tons of time and money. You are required to split the cost of arbitration. So it's really, really financially feasible for people. And 9 times out of 10, you will always resolve the dispute with arbitration. It's a lot more formal than a mediation process. So I highly suggest you put an arbitration clause in there. It will save you thousands down the line if you potentially get into a situation where somebody could file suit against you, or you file suit against somebody else, and instead you will go arbitrate it with a third-party arbitrator instead to resolve it. So the next is a cancellation and rescheduling clause. So this can be combined into one clause, but I often recommend that it be 2 separate clauses because it's really easier for your client to understand and go straight to like the cancellation clause if they plan to cancel their event or their contract with you altogether, and vice versa. So if they're going to reschedule and say just change their wedding date to another day, or if they need to reschedule a launch period, if you're a coach or something like that, then you would put a grace period in the rescheduling clause. So I like to lay these both out as 2 different clauses. Some people have them as both though, which is why I like to talk about them as both because they do coincide together. The clauses lay out the canceling and rescheduling procedure. So the time that your clients must inform you of cancellation or any type of scheduling change in order to get their deposit or retainer back and to not have to pay the entire fee. So for cancellation, industry standard in the online world and in the wedding industry world is usually 30 days prior to the event date. So if they cancel prior to 30 days to their wedding, they are not liable for the entire full fee because they've probably paid you a retainer. And then if they if they cancel anything within 30 days, though, they are liable for the entire amount because the likelihood of you being able to rebook that date is very slim to none. Rescheduling clause gives more of that grace period that I was talking about. So it would include something like whether you honor a 6-month rescheduling situation, 12-month rescheduling situation, 18-month rescheduling situation. And the key word here is you make your deposit and or retainer, sorry, it's not deposit and retainer. You would make that transferable. That's the word here, keyword. So in your retainer deposit clause, you would want to say something about it being non-transferable, non-refundable, except in the case of a rescheduling event, if you want to give any type of grace period. Some people don't like to give grace periods. They just like their deposit and retainer to be really just non-transferable, non-refundable. So in that case, that's when I would suggest a cancellation and rescheduling clause come together. And it just means that they can't get any of their money back at all. I just always suggest we be better business owners and we give some grace period for our customers. Life happens, things happen, and rescheduling happens all the time in the wedding industry world and also just in the online world when we're doing any type of work with our clients. So all in all, the biggest clauses, this is probably the biggest clause that you need to have as a photographer, videographer, venue owner, wedding planner, because you block out dates in your calendar in advance of that wedding event. And sometimes you do this over a year in advance and you say no to tons of clients when they inquire about that date because you already have it booked. So if you have a client cancel or reschedule, the ability for you to rebook that really is non-existent. And you could be out thousands of dollars if you don't have these clauses that state when and how they should cancel or reschedule. So make sure you have that clause in there. Finally, the last most important clause to have is a force majeure clause. This is also called an act of God clause or a limitation of liability clause. You can have this, but I like force majeure because I used to live in France, and in French, this means of superior strength. So if something of a superior strength happens in the world, you're not liable under your contract for performing your obligations. So if like a tornado happens, a hurricane happens, a flood happens, you get hit by another car, you get in an accident, you get severely ill, your family member dies, et cetera, You are not obligated to perform under the contract until the act of God is resolved. This is also a vice versa, a two-sided clause. And so you also want to ensure that your client isn't responsible for their obligations until the act of God is resolved. This covers you and your clients in any of these events if something were to happen to them or you. And it's really, really good to have this. And this coincides with that transfer clause, because if an act of God were to happen and you might have to transfer something, you're not liable. And then the transfer clause says that you just need to inform your client of whomever is going to take your place, and they need to agree to it. So, you guys, we've gone through all of the necessary clauses in your contracts. Obviously, there are more clauses that are very specific to certain businesses that I would add into these contracts, like posting on social media, any type of editing clauses for all of you photographers and videographers out there, like rounds of edits, communication in terms of if there's any additional tangible products that you offer your clients and what that process looks like. There's so many different other clauses that are very, very specific. So these are just the general ones. Again, I want you to make sure, as I go through this list one more time, that you are checking those boxes. It's really important for you to make sure that you have all of these in there, and you can highlight and check them off, and it'll make you feel so much better and give yourself a pat on the back. There's also places for notes if you want to take any notes that we've had throughout these two episodes as well. So we have gone over the entire agreement clause, the description of services clause, a venue and jurisdiction clause, a severability clause, a transfer clause, a billing structure clause, an intellectual property clause, a counterparts and facsimile signature clause, a communication clause, an indemnity clause, an arbitration clause, a cancellation and rescheduling clause or clauses, and a force majeure clause. You guys, I am so proud of you for listening into this two-part series on all of the clauses you need to have as a service-based company. I think you are literally so many steps ahead of your colleagues in the industry. If you have listened to this, you have gained a wealth of knowledge about these clauses in your contracts. Hopefully now you can communicate your clauses better to your clients as well. If you have any further questions for me, please don't hesitate to reach out. You can reach out to me on my Instagram account, The Legal Page. You can also reach out to us at the Legal Page community on Facebook. Just type in at the top search bar on Facebook, The Legal Page community, approved to join, and you can ask all of your questions in that private Facebook community. We would absolutely love to have you there. Chat soon, Legal Pagers. Next week's going to be a really awesome episode, so stay tuned. Thanks so much for listening to this episode of the Legal Page podcast. See, I told you being legally legit isn't so scary. Be sure to visit thelegalpage.com for all show notes. And it would be super awesome if you could head over to iTunes and leave a review. Last but not least, don't forget to join my free Facebook group for unlimited legal and biz Q&A. Chat soon, Legal Pagers.